Hi, thank you so much for being here today. You are in legal issues or legal things that you need to know as an independent author and entrepreneur, just so you know you're in the right room. First of all, I want to thank 20 Books for asking me to speak. This is the first time I've ever been to this conference. It's very exciting. I'm really enjoying it, and the speakers are really amazing, so I'm honored to have been asked. So I want to thank Craig and Michael and the 20 Books group. So this is me. I'm going to run through these slides. We've created a little bit of a presentation. So the first thing is legal issues for authors, what every author needs to know. So when Craig corralled me at NINC and asked me to speak, I had given a copyright and trademark speech or presentation at NINC, and I had done books to film at NINC, and he asked, will you come over? And I said, yeah, it's only an hour by plane. I'd love to. I've never been before. In the before times when I was around people, So I put this together. It's a new presentation. And the thing is that he didn't really tell me what I was going to present on, right? So I just kind of assumed that I was presenting on the same things. So then I looked at that Google Doc, and I thought, I've never done a presentation on legal issues for authors. And then tomorrow I'm speaking on, what does he have me speaking on? He has me speaking on copyright and trademark and licensing. And I texted or I messaged Craig and I said, well, what does this mean? What do you want me to do? He's like, I don't know. And I've heard from other speakers that that's kind of what he does. He collects his people and then he's like, they're smart, they'll figure it out. So this is my rendition of what Craig wanted me to do. So we'll go from there. All right? So I have to give you this. It's a lot of disclaimer. It's a lot of language saying, yes, I am an attorney. Yes, I do have my own law practice. I'm not your attorney. And if I am, this is not my legal advice to you necessarily, because you'll hear from me at any given time about what I think you should do, right? So, you have to sign an engagement letter with an attorney to have them be your attorney. So this is my little legal disclaimer. So about me. This is who I am. I've been told that it's necessary to do that. It's a great picture, isn't it? So I had a lot of help with that. I told the makeup artist, the pictures when they take them look different. And I looked at those pictures. They're in high resolution before they fix them. And I was like, I earned every one of those lines. I earned every one of them. So I'm a USA Today bestselling author. I'm very proud of that title, of over 20 books. I also founded a legal practice which kind of grew up organically around me through word of mouth. I thought that I had left the law behind when I published my first books, but my friends and writer colleagues figured out my dirty little secret about being an attorney and understanding books to film and TV, and so now I have a law practice. So I want to start out talking about, here's the thing. As authors, this is where your magic is, right? It is magic, what we do. It is absolutely magic. So the thing that makes it magic is that as an author, you're able to go through space and time. You are a time traveler. I mean, let's think about it. Shakespeare wrote his works how many hundreds of years ago? I can still read them and laugh and cry. So it is magic what we do as authors. We're able to create emotions, visions, all of it with other people. So don't ever minimize, not that you would, what you do as an author. But the thing that's really fascinating for me is indie authors who are also entrepreneurs, because that is not necessarily a natural sort of bridge in the brain to be able to be incredibly creative as well as incredibly business oriented. I don't even know what the odds are on that, right? So you're also a business owner and an entrepreneur. And I feel like that's a mindset that sometimes authors take on after the mindset of being an author, even if they were an entrepreneur in another sort of endeavor, right? The idea that this book thing is a business. So this is my picture of an entrepreneur. So your business is the creation, management, and sale of intellectual property. You got to do all of it, right? Until you get big enough that you can hire other people to do some of it. But regardless of which parts of it you have to do, this is your entrepreneurial endeavor. And this is what it feels like in the beginning. Right? For a lot of authors in the very beginning, it feels like Sisyphus. Book after book, word after word. Oh my goodness, I made $2 today. Why am I doing this? Will I get any readers ever? You know, it can feel, or the traction of trying to learn all the things. The Facebook ads, the Amazon ads, the marketing, the promotions, the Facebook group, the Instagram, the TikTok, so much for one person to do. So, but what generally can happen, I have a lot of clients that this was kind of their path. A lot of clients, let me just give you an example, one in particular. One woman had an outside job, great gig, decided she wanted to have kids and stay home with them. She started writing, and she started writing to be able to have something for herself as well as to make a little bit of pocket money on the side, right? Like this was meant to be her side hustle that she could do when she's sitting in the car waiting for the kids at soccer practice, right? Not to be too cliche, but it's real. So the thing is that she just was putting books out, and it was about book 6 or 7. This is what happened, right? Rocket ship to the moon. Nothing in place because she never thought that it would become something big and something all of a sudden, not all of a sudden. It's never all of a sudden. Book 7 is not all of a sudden. We say that, but there's a lot of hard work that comes in. What is the saying? It takes 10 years to become an overnight success. It's true. It's true. You can clock it. Even with the kids that are on TV shows that are only 20, they started when they were 9, right? So it's like a rocket ship to the moon. And the challenge is when that happens is that while you're traveling at this speed into space, you're building your rocket ship as you're going, right? This is what happens for a lot of authors is they haven't kind of built the foundation. And all of a sudden they're faced with, I've got to have help with my ads. I've got to have help with my formatting. I've got to carve out time to be able to write. What do you mean they're offering me an audio deal? What, who, how, what? So this presentation is supposed to be able to give you kind of an overview of some of the legal issues you face as an author. And it's also to be able, according to Craig, he wanted you guys to be able to feel informed enough to ask better questions of other people. I mean, I hear a lot that one of the reasons people like to talk to me about it is they know I'm an author too, and I can't tell you the number of authors who have said to me, Maggie, I love talking to you because I never feel stupid because I know that you're an author too. Here's the thing, quick secret, authors are always the smartest people in the room. Right? 100%. And here's another secret that I know, because if the executives and the publishers could write the damn books themselves, they absolutely would. Right? So always remember, you're the smartest people in the room, and you're also employing everyone else, okay? So today I want to discuss some of the legal issues that are both unique and not so unique to authors. And here they are. I can't drill deeply into all of them, but I can give you an overview. I can tell you that tomorrow I'm going to speak on brand assets because that's trademark and copyright. And rights management, I'm going to speak tomorrow on licensing, which has a lot to do with rights management. Film and TV is one of those areas that I love to speak on, and I'm not doing it here this time, but I'm going to touch on that briefly in my rights management speech tomorrow. So business structures. Okay, so LLC, C Corp, or S Corp? I don't know. No, I do know, but I say I don't know because I don't know what's best for you. And let me tell you why. When an author comes to me and says, should I do an LLC, a C Corp, or an S Corp? I say to them, do you have a tax attorney or an accountant? If you have a tax attorney or an accountant, ask them first. Because primarily these, when you're an author, primarily these are about how do you keep your money, right? We're not really creating high-risk product that is going to put you in a liability challenge the same way, say, medical devices do or whatever, So this is more about your tax structure. I know a lot of authors will start with an LLC, and when they start to make more money, they'll move into a corporate status. The LLC is so state by state. I'm from California. They charge $800 franchise tax every year regardless. For an LLC, it's not like that in Texas, I'm told. So this is a very individual sort of choice. What's right for you? Consult with your CPA or tax attorney. Okay, so contracts and agreements as an author, entrepreneur. I have strong feelings about contracts and agreements, and it's because I've seen the downside of not putting them in place, or the downside of not negotiating them, or the downside of just accepting them and what that can do to your rights. So I'm a big believer, what types of agreements do you need? I'm a big believer in papering a deal, as I say. It doesn't have to be me who papers your deal, it doesn't even have to be an attorney who papers your deal, but if you get into bed creatively with someone else to write something, write down what you think it's meant to be. Well, most authors work with vendors, and many work with other authors. Some of the agreements authors need. So co-author agreements, that one to me is super important because co-authors are often people that are your friends. I just had a phone call yesterday with this incredibly creative and talented comic book author who his relationship with his co-creator has gone south, and now they're trying to figure out who's going to sell to who, right? And how they're going to get out. They can't even talk to each other anymore. And they never wrote it down, right? They never wrote down the buyout procedure, and now they're not friends anymore. So I think that it's really a good thing when you're still in sort of that honeymoon phase that you write down what are the details? How do we get paid? You know, what happens if we don't like each other anymore? Writing in an author world, this is kind of a big thing too. A lot of authors are starting to have their own worlds. This is often a licensing deal because when you bring authors into your world, you need to determine if they're going to write in my world, am I licensing them the rights to certain characters in my world in perpetuity? If that book reverts back to them and is no longer covered under our agreement, do I need them to strip out the elements that are from my world, or am I going to allow them to keep those elements even though I'm no longer getting paid for that, right? Cover designer agreements. I just ran into a problem with a challenge. It has to do with the cover art for this one. Author did her due diligence, reached out to the photographer, thought she was licensing an image to put on her cover, found out after she had published it and received a nasty cease and desist that the photographer did not have those rights to convey. Yeah. So I would say that you want to do your due diligence, you want to kind of suss it out, and she didn't come from me, she did it her own. She already had a written agreement and the photographer had signed it, but the photographer didn't have the rights. He didn't have the right to license that image for a cover. All right, so work for hire agreements, editor agreements, PA agreements, non-disclosure agreements. Those can become kind of important, especially with pen names, privacy. One of the things I think I highlighted here is the work for hire agreement. Those are really important. So a lot of people utilize the services of ghosts, or they'll have somebody else that's writing, or they're paying someone else. That work for hire needs to be explicit within the agreement, and there also needs to be language within it that if for whatever reason the work for hire language is found to be invalid, the work for hire agreement also acts as an assignment of rights, okay, so that they're yours. Did I talk about this? One of the other things I always like to talk about when I talk about these different types of agreements is, so also going through this co-author agreements. Here's the thing. If you're a joint copyright holder, a lot of people don't realize this. If you're a joint copyright holder with someone else, say you've got author A and you've got author B, and they're joint copyright holders because they created a work together. They're communicating their friends. Oh, it's kind of like this comic book guy I know. They have a falling out, so they're no longer talking. Technically, as a joint copyright holder, author B can sell the film and TV rights to the book without ever telling author A. So you can license and sell your subsidiary, ancillary, and derivative works for things that you hold a co-copyright with without telling anyone else. Unless you have explicitly stated in your agreement, your co-author agreement, that you will not sell, exploit, assign, do anything with the ancillary and derivative works, subsidiary, ancillary, derivative works, without the express written consent of your co-author or your co-copyright holder, right? So that's one of those pieces of language and little tidbits that I think was worth the price of entry. Super important. So negotiations. There are some authors who love to negotiate. I love to negotiate for other people. It's one of my favorites. And there are some authors that absolutely do not. So when you're presented with an offer for your work, whether it's film and TV, whether it's an app, an audio, a translation, anything at all, my advice to you is that agreement that is presented to you by the corporation who wants to license, buy, do whatever with your subsidiary rights, is in the light most favorable to the corporation that drafted it. Always, 100%. So what you need to do is you need to negotiate. When you are presented with an agreement, read the agreement, negotiate the agreement. And that includes the terms as well as the money. And when I say terms, I mean how long and how much, right? And also what rights. So this is the red line of an agreement. This is what I spend a lot of my time doing during the day when I negotiate. This comes after we close the deal. So if you get a monetary offer, I think there was a example I wanted to get. Yeah, so when you get a monetary offer, you need to ask for what you want in your agreement and let the other side tell you no, right? Don't tell yourself no. Let the other side tell you no. So I have a client who was offered, what was it? I think it was $50,000 for their film and TV rights from Lionsgate. I went back and asked for $1 million because that was the value of the property. I got a phone call from Business Affairs because they already had a showrunner. They knew exactly what they were doing with it. They already had a distributor. I got a call from Business Affairs, and I knew this guy. He's like, Maggie, why does this say $1 million? I said, because it's the value of the property. You have the showrunner, you have the producer, you have the distributor. This is an underserved market. It's a huge, I think it was a comic book. This is a huge comic book series. There's no reason why you shouldn't pay this. He's like, we're not even in the same ballpark. I'm like, okay. Fair enough, but you undervalued the property. It's worth more than $50,000. You and I both know that, especially with the package you've managed to put together before you even entertain presenting an offer to my client. So we were able to close it for mid-6. Mid-6 is a lot more than $50,000, right? So I would say that you always ask for what you want and negotiate your deals. This is with anything, Tantor included. Right? The other thing that you need to kind of come, and I talk about this tomorrow in licensing, you need to be comfortable with the idea that if they're paying you $10,000 up front, they're making $100 to $500 to $1 million, right? Be aware of it. It's because corporations, when they offer you a whole bunch of money up front, they're making a lot of money, right? And this is your participation. Some authors are like, that's fine, I don't care. I'm not going to build an app, so I'll just take the money and put it in the bank, you know? Rights management, AKA intellectual property portfolio diversification and management. Aren't those fancy words? They're such fancy words. All right. So I start with this. So the seed represents your book, right? You write one book, and from that one book, there's all kinds of rights that flow, right? Like I'm going to talk about this tomorrow in my licensing speech, or trademark and copyright too, I think. So every single branch is a different sort of right that is available to you as the author of the original book to exploit. Translations, audio, foreign, which falls under translations, film and TV, apps, gaming, merchandising, stage, podcasts. These are all different rights that can come from one single title. Oh, here they are. Publishing, film rights, TV rights, audio rights, comic book rights, translation rights, gaming, app rights, and merchandising. So these can all come from one book. The thing is that each one of them will also come with its own contract, most likely, that you or someone who knows more about contracts should read and review and negotiate on your behalf. I love this slide because what you're trying to do is you're trying to squeeze as much money possible out of each and every book, right? You took the time, you wrote the book, you want as much money as possible to flow from that one title. So, I don't know where I am on time. Okay, brand assets. We all know what these brands are, right? There's only 2 of them that even have letters, and you immediately, upon looking at them, I think I'm having the same problem Mal had yesterday. So upon looking at them, you know what they do, the companies, all of it. So that is, without a doubt, brand value. And some would argue that the value of this image informing your brain as to all of the details is as valuable, in some places maybe more, than the actual things that they create, right? So as an author, what could your brand assets be? Copyright, pin name, series name, and logo. So each book, you're going to want to file, right. So for each book, you want to file for copyright. You can pay someone like me a lot of money to do it, or you can do it yourself. Copyright is definitely doable, 100%. The website is a little bit archaic, but once you've done it once or twice, you'll be able to get through it. It's not super expensive, a little time consuming, but do file, because it does provide you with a lot of protections. It shifts the burden of proof away. If there's a copyright infringer, I'll talk about this tomorrow, it shifts the burden of proof from you owning the copyright to the person that's infringing. And it also allows for you to have statutory damages, which oftentimes will allow you to find a litigator who will take your case if you're being infringed upon, okay? So I would say take the time and file for your copyrights. Trademark, a little bit different. Takes a little bit, so you have to do a worldwide search for a trademark. So my firm does those. We do a worldwide search, and then we write an opinion letter. We go through it. We check to see, and then we file. And you can get actions back from the USPTO if there's a challenge to the trademark or something like that. So that one's a little bit, not to say that you can't do it. I would never say that you can't, because you can as an individual. You don't have to be licensed to do it. But I can say that trademark is a little bit more touchy, because you have to have the appropriate classes, and you have to have the appropriate description to the classes, and you have to submit specimens to the USPTO. But these are brand assets that you as an author have. And the things that can be trademarked are if you have a logo, if you have a pin name, or if you have a series name. You cannot trademark individual book titles, but you can trademark series titles. So I'm going to just touch on this because this is a hot topic that is coming up more and more, and I think it's because nobody gets out alive, right? None of us get out alive. So, and a lot of people are building really substantial literary estates, and the challenge is the same as it is for every entrepreneur that builds a business that they love. Who's going to take care of it when I'm gone, right? Like, who is going to be the business person who understands how to do this? Best case scenario, I was just thinking about this the other day. So Dune, which I'm rereading because I love the movie so much, as you know, his son has carried on in his father's name. Not only has he written more books in that world, but he manages the assets of his father's literary estate, right? Best setup ever. I have spent hours encouraging my youngest daughter to become an author. I don't know if I'm going to get there. You know, she's a really great writer. She's very creative, and I think that she would be perfect to manage not only her assets, but mine. So this being said, estate law. It is very state specific, right? So I can only advise people. I don't do estate law, but I have no attorneys that can, and I can give a little bit of overview with regards to how it is in California. You're going to want to find an estate attorney in your state who has a background or has some familiarity with intellectual property. That can be kind of tricky. I did find one in Georgia based in Atlanta because there's a lot of movies and TV production in Atlanta, but there are some states where that's not necessarily a crossover that is there a lot. You can't throw a stone in LA without finding an estate attorney who understands intellectual property, because there's so much work there for that. What was I going to say? So if you can't find the estate attorney with that background, you're going to want to find an intellectual property who can at least have a conversation about what you want. Find an attorney who understands not only your state's estate law, but an attorney who also understands intellectual property. consider appointing an executor for your literary property. So here is what I know, or what I've been told from an estate attorney. One of the challenges that takes place, you have 100 books. So you have 100 books, and you have 3 kids that are going to be your heirs. And say the hypothet that I'm creating, your spouse predeceases you. You have 3 kids that are going to be your heirs. You have 100 books. If those books have not been adequately taken care of, and I would say probably put into a trust, I'm thinking, if they've not been adequately taken care of, for any cover change, any edit, any marketing, any Amazon ads to take place, all 3 of your children have to agree on it. All 3 of your children have to agree on it. I have 2 kids. I can't get them to agree on what to have for dinner. Okay, so imagine them trying to do cover design and marketing. So that's why I think it's a great thing if you have one who kind of wants to do it, enjoys it, thinks it would be fantastic, or if you have 3 that can agree on it, you can appoint them kind of the executor of your literary estate. And then they can make the decisions, and you can also work it out where that if they're doing that work, they can take a percentage of what they earn from doing that work. There are also places that do this, literary estate management companies. You can train an heir how to manage your literary estate. You can have an attorney or an agent. So here's the thing that's interesting is that before the advent of indie publishing, traditional publishing in combination with agents often took care of these things for the heirs, right? Because the publishing house had a dog in that fight, so to speak, right? Or a horse in that race, because they wanted to make sure that those books were still earning money for the publishing house. But now as indie authors, all that money flows to you and your heirs. So now you've got to kind of sort out how you want to do that moving forward. I'm a big believer in this. And I know it makes some people really uncomfortable, but to discuss your desires as to your literary property, and I would say even all your other property, with your family or your heirs, whoever that's going to be. I've seen some really nasty fights go down because nobody had a conversation about how they really wanted it to happen afterwards. And then have a conversation with your estate attorney and work it out, right? I mean, some people, and I think this is brilliant, actually sit down with their heirs and go through their will, right? And so that the heirs know exactly what's meant to happen. I guess it could cause some bad blood if you're kicking somebody out, but that's some of the writer part of my brain. Okay, so you are an author and an entrepreneur. And again, I think that oftentimes we focus on one and not the other, and I think a penny of prevention can prevent a pound of pain later on. A lot of these things is really about preventing things on the front end. You don't run into problems down the road. Your books or your business, be prepared for the legal issues that are specific to your business. All right. And that's I got 10 minutes for questions. So this is all of my stuff. This is a QR code that will lead you to my website so that you have that. I need the fancy one that will download directly into your contacts, but I don't have that yet. So who can I answer? What kind of questions can I answer? If I don't know the answer, I'll try to find it and circle back to you. Also, if you have questions about things that I didn't cover, you can always grab me at the conference, and I'll try to answer your questions. Yes. There's a hand right here. First hand. Oh.
Slides will be available.
Yeah, I can do that. Absolutely. I'll put it in the Facebook group. Is that, yeah? I didn't send them in early. Yeah, but I can do that. Yeah.
At what point would you recommend hiring a lawyer for your literary career?
It's such a personal question, right? Because there are definitely costs that come with hiring an attorney. I would say before you run into trouble would be before the problems arise. When you start, a lot of times people come to me when they get their first offer for a licensing deal, right? Or when they need a contract because they're going to co-author, or they want. So those are oftentimes when I first see people, right? Is that they need some help with something. And here's the thing I always say: read your agreements. Read them. I understand a lot of people don't want to, and they don't, and that's, I know, it's a personal choice, but read your agreements, and not only read them, but maybe have someone who's smarter than you, or not smarter, but who has seen more agreements, whether it's another author or not, read them as well. Was that a loosey-goosey answer? I'm sorry. So, I think I got to go to the microphone.
Okay. I have a question. I publish nonfiction books.
Yeah.
You know, like books like for dummies.
Right.
They publish like trademark terms like for dummies, Facebook for dummies, you know, Pinterest for dummies. Can I publish books where I have terms like Facebook if I have the trademark on the top right into my book title?
I'm more concerned with the for dummies.
No, I'm not going to use the word dummies.
Yeah. Do you have a licensing deal?
I have my own
No,
trademark.
no. Did Facebook say you could use their logo?
No.
Well,
Then I can't.
I
No,
think,
just
well,
wanna know.
can't is a very strong word. So, yeah, you know what? You may get a nastygram. You could get a cease and desist. You know, Facebook, I think you've seen how this company, they tried to put out a business, Meta, right? Like, so they're pretty litigious, and they have an army of people like me who are not quite as nice as I am.
Okay.
So, some of them are. That's not nice. Sometimes I get quippy, and I don't think about what I'm saying. Sorry. Yes.
Hi, Maggie. So I have just a quick question because we generate contracts, right? So oftentimes we're making anything from NDAs to work for hires, whatever it is. And there are many times where, as you say, someone wants to negotiate.
Right.
Right. Okay. So in what respect, like if I'm adding something very small to a contract, at what point do you think I should have that contract re-reviewed by an actual lawyer who has actual experience?
So I want to make sure that I'm processing what you're telling me accurately. So you generate contracts that you send to authors.
Right.
The authors then will come to someone like me who will redline the agreement and want to change or modify the agreement.
No. If it's like that, that goes right back to my lawyer, right?
Oh, okay.
Right. So no, it's more to the effect of they say like, hey, I see that you have this in there for you. I want that there for me as well, right? And then you can just easily, kind of copy paste and say, hey, this, or you can just say, hey, this is for both parties, whatever it is. And so when you're making small changes over time, obviously, like if you want that, if you think it's a good agreement, like CMITs, right? Or crimes of moral turpitude, stuff like that, where you're adding stuff like that in. At what point do you think that contract should be re-reviewed, or do you think it should always just be the lawyer handling that?
What do you do?
I own a publishing company.
Okay. Oh, so you're the publishing house. I represent a publishing house, and here is the challenge, is that I think that you really have to be able, if you as an individual who owns the publishing house feels like it has not changed the agreement so substantially that it's going to put you at risk, but that is an individual's choice, right? So, and without seeing the agreement and kind of understanding what the modification is, because the word not or no in a contract can change the entire contract, right? Will do versus will not do changes an entire, setup. So I think it really comes down to what your comfort level is as far as that agreement. And I think that it would be great if you have had a long conversation with your attorney so that you... contracts are a lot like cars, and some of them cost as much as cars, Yeah. So I think that if you're as an attorney, oftentimes will have a long conversation with a client about what the meanings are, and what kind of changes are going to be really have a big kind of impact.
I can tell you that I am very comfortable with what I'm
Yeah.
doing, right? And my lawyer is comfortable with what I'm doing. This is more of a general, like for
Yeah.
people that are doing this, because I wanted to hear more official answer than what I could give to someone.
It's really an individual's choice, I think, with a comfort level. Yeah. Hi.
Hi. It makes sense, of course, to negotiate a contract if you can, but my question is, thank you. My question is, you've been given a contract and you say, oh, I would like to have this, this, and this. And the answer you get is, oh, honey, we never do that. This is the contract, take it or leave it.
Right.
So my question is that just make you go away kind of thing?
You have all the power in
prevalent
that
is that?
situation. You have all the power. So you get a contract, you go back and you say, I want these 5 things. And they say no. What are your choices? You accept the contract or you say, see ya, you have all the power. It's your intellectual property. It's your decision, right? And that's how I see that. But I think you have to be really willing to say, this doesn't work for me. There are a few things that are a hard pass for me that I will say to my clients, I think this is horrible. I don't think you should do it. But then the client or the author has to make that decision. There are a lot of times where I will say to a client, I do not think you should accept these terms. And they'll say, I want the deal. And I'll say, okay, then take the deal. So it's really an educated sort of decision that authors make. There are publishing houses that will not negotiate their agreements. And then you have to decide if you're willing to live with the terms that are presented to you. Does that make sense?
Yes.
Yeah.
Thank you.
Mm-hmm. Hi.
Hi. So I wrote a memoir about my life in Alaska
Uh-huh.
for 20 years. And it's the first book in a series that I have planned. The rest of the books are about other people who've lived in Alaska.
Mm-hmm.
Many of them are gone now. So they're people I knew or people I was related to, but they also have other family members, and everyone has a skeleton in their closet. So the more research I do, I go to the next book because I'm afraid. Then I come up with more skeletons, so I go to the next book because I'm afraid. And so I'm just wondering, what liability do I have in writing people's stories? To give you an idea, the very next book starts with the sale of a 14-year-old girl by her father to a 45-year-old man.
Right.
And she marries him and ends up with 4 children before he dies 4 years later. It's a true story.
Mhm.
It happened. But the children today will tell you that their father was a great man and that didn't happen. But the youngest child is a child of another man.
Right.
And she said, her mother said that she was sold by her grandfather.
Right.
So there's conflicting stories. So what liability do I have if I write that story as a true
Right.
story versus as a fictional story that was based on a true story?
So I think that the question I always throw back when somebody says, what liability do I have, is how litigious are those children? And how much money do they have? And will they hire an attorney? And will they sue you? Right? Because nobody wants a lawsuit. It's super expensive. It's like $50,000 to $75,000 just to walk into a courtroom right now, right? So here's the thing. Without reading it, I can't tell you, but is it a public figure? If not, then you're running into all kinds of sort of issues because defamation and libel. Anyone can walk into a courtroom and file suit against anyone else. Whether or not that claim holds water, it could get dismissed. It could have a motion for summary judgment. It wouldn't get through that. But those things mean that a suit has already been filed. So I would say, is there any way that you can get a license? Isn't the right word. I'm blanking. A release, a waiver, something that those children will sign that will allow you. Or the other thing is, can you keep the facts but fictionalize the people? Because the courts give wide deference to fictionalizations,
So
right?
if I wrote it as a fiction and said that some elements are true, or just make it like it's totally fiction even though I know it's true?
I would call it historical fiction, right? Would a pseudonym protect her? Oh, the character names are different. So the courts, like I said, have given broad deference, right, to fiction works, a higher deference as to what you can do. So if you can sit on a witness stand and say, while I may have been informed about real life events, these are characters that were created in my mind, and it's based on some real life events, but these characters were created by me, then you could be in a safer spot. But again, I can't really give you legal advice. And if they get really angry, they could still file suit. And you get a nasty gram, and you can get a cease and desist. And yeah, it can become icky. Unless it's a public figure. Like if one of these people had been the governor of Alaska, or if it was a matter of public interest, like a big crime, then you have more wiggle room. Hi.
Hi, thank you for taking our questions.
Oh, yeah.
Mine is a 2-part question. I have a new LLC,
Mm-hmm.
but I don't know the actual act I have to do to put my creative, my books, screenplays, that kind of thing,
Right.
into the LLC. And the second part is, can I put that LLC into my trust?
The second question, LLC into a trust, you're going to want to talk to an estate attorney that is specific to your state. My inclination with that is to say yes, you can, but I don't know, because it's so state specific. As far as putting your works into the LLC, have you filed for copyright on all of them?
Yeah.
You have. Okay, so I believe that it's really an easy sort of transfer mechanism to shift the copyright. The other thing that you could do is you could do a quick 2-paragraph document that says that you, the individual author, convey all rights, title, and interest to your LLC.
Oh.
And then I would also put a little paragraph in there that said that if the LLC were to not exist, that all of those rights, titles, and interests would automatically revert back to you.
Okay.
Again, not legal advice, but something
No,
that
that's helpful.
could,
Thank you.
could work.
Thank you.
Yeah. I think my time is up. Sorry. But I'm happy to chat and stop. 5. Oh, okay. Yes, I'm sorry.
All right, so my question's kind of a very basic question. When I published my first book about a year ago,
Yeah.
I put all the money.
Congratulations.
Thank you.
Yeah.
When I published, I put all my money into the book and didn't file the copyright with the U.S. Copyright
Yeah.
Office. Since it's been a little over a year, am I still able to
File.
do that?
Just file.
Okay.
Yeah, there are some protections that come if you do it before the 5-month mark, but I would still file because then it still will shift the burden of, so if you have a copyright infringer right now, if you sue them and you don't have the copyright, you have to prove that you actually were the writer. If you have the copyright, it shifts the burden where they have to prove that they wrote it. So I'll go ahead and file.
All right,
And
thank
it's
you.
not super expensive. I think it's right now it's like $65. I have a cheat sheet on my desk, but so
Okay.
yeah.
All right,
Yeah.
thank you.
Hello.
Hi. So super quickly, if you don't have a lot of money to
Yeah.
hire an attorney and everything, would you advise one of those prepaid legal services to kind of help you with all those little things getting started, even though they might
Yeah.
not know much about intellectual or
Yeah.
that kind of thing? Or would that just be sort of a waste of your
I
money?
think it's a really personal sort of decision. I can tell you that LegalZoom used a law firm to file for trademark.
Okay.
They didn't file for their own trademark.
Great.
You can look that up.
I've got an entry similar to the lady that was up talking about her family.
Mm-hmm.
I've
Family's fun, isn't it?
yeah, this is not family though.
Oh.
This is. I have a story. It is about a man, and it's a trilogy. Historical facts, lots of fiction.
How historical are we talking about?
It's through 1950 from.
Oh, okay, so there's still possibly living people. Okay.
He has no children.
Mm-hmm.
And I'm wanting to use his picture on
that's a good one.
on my author page rather than my picture
Mm.
because it's historical fiction and
Mhm.
it's basically war stories.
So, it's interesting that you asked this question. I just did get into this. So I have a client whose father was a really important and impressive photographer, and he manages the rights of that estate, right? Really big documentarian. You may be familiar with him, did some movies on baseball. Used this photograph without licensing it, and is now on the hook for having used the photograph in the documentary without licensing it properly from the estate. So if you're going to use that photograph, you need to find out who took the photograph, and go ahead.
It was like in Germany or there's no way.
How did you find it?
In a estate sale, not in a estate
Oh,
sale, but
right.
a locker auction. Those storage wars.
And is the photograph a public figure?
Not anybody that anybody would know.
So this is the thing, is that you would be using it at your own risk, right? You don't have a license to use it. So
Would I be able to file for a license for it?
who would you file
I
with?
mean, that's what
No. So you either have got to do some due diligence and figure out who took it, see if there's any rights to it, stuff like that, or you use it at your own risk. So there's a lot of times when you can't say 100% you're going to have no risk, right?
Yeah.
So you've got to just kind of in your mind determine. And really what would happen probably, let me play this out. What would probably happen is that if somebody did have the rights to the photograph, they would send you a nasty gram saying take it down. right?
Okay.
And then you would take it down. I do have, like I said, that one case where I've got, in my opinion, a little bit of a challenging person on the other side, who thinks that the use of a photograph warrants him receiving a ton of dough, which I just don't agree with. So
Okay.
it's kind of at your own risk with that, I think.
Okay. Thank you.
Likelihood, no. Possible, yes.
Well, you know, the picture.
How's that?
Most the person that took it's long dead, because this is a picture of a 18-year-old boy.
Yes, but they could have bequeathed that photograph to an heir.
Okay. Thank you.
The copyright is, but the photographer could have been younger. Go ahead. Did you have a question? Yeah, but they're out of time. Okay, well, I'm happy to answer.